Well, so we shall now come to the supervisory jurisdiction. Supervisory jurisdiction, High Court is the highest judiciary in the state, and it has also the supervisory power over the subordinate courts. The High Court has power of superintendence all courts and tribunals inside the country, inside the state. So that is also a type of jurisdiction. The High Court decides and make and issue general rules and prescribe forms regulating the practice and proceedings of theirs, and it also decides the fees and the administrative charges or the court fees and others, fees payable to sheriff, clerks and officers and legal practitioners of them. So everything related to the administration of courts is finally decided by the High Courts. It is called the supervisory jurisdiction of the High Court. High Court has a lot of superintendents. It extends to all courts, tribunals, whether they are subject to appellate jurisdiction of High Court or not. And it covers not only administrative superintendents but also judicial superintendents. So superintendents means both administrative and judicial superintendents over all courts and tribunals inside the country. That is a kind of things also we have to remember. It can be so moto also, and the power does not vest High Court with any unlimited authority over the subordinate courts and tribunals. It is an extraordinary power, hence has to be used most importantly, because subordinate courts and tribunals have also their original jurisdiction, have also their independence in acting upon that. So it does not mean that under supervisory power, supervisory jurisdiction, High Court can take any step, any measure to against or towards the subordinate courts. That does not mean it is generally used. Usually it is limited to excess of jurisdictions and gross violation of natural justice and errors of law, disregard of law of superior courts, previous perverse findings and manifest injustice. All these things are there under the supervisory jurisdiction. So this power is not extraordinary. This power is not an ordinary power of the High Court. Rather, it is an extraordinary power of the High Court. It can be used. Supervisory power can be used in certain exceptional circumstances. But overall, the High Court supervises through prescribing the norms, rules, regulations, and also the procedures, the fees, and etc. related to subordinate courts. Now, the control over subordinate courts. Control over subordinate courts. Control over subordinate courts. Control over subordinate courts. So it is also a kind of jurisdiction of the Supreme High Courts. Under that, the High Court is the controlling authority. Is the controlling authority in order to appellate jurisdiction and supervise jurisdiction over the subordinate courts are mentioned above. High Court has also the administrative control and other powers over them. So High Court is consulted by the governor in the appointment, posting and transfer of High Court judges. So that is called the control over superintendence courts. So it is administrative control. The High Court is consulted by the governor in the appointment, posting, transfer of district judges and other members of subordinate judiciary. Kindly take a note of this. Okay. Then we can say that number two, it can withdraw any case in a subordinate court, pending in a subordinate court, pending in a subordinate court if it involves a substantial question of law, that requires the interpretation of the Constitution. That is also comes under the controlling jurisdiction of the High Courts. Please take a note of that. Okay. Okay. Next next point, that is its law are binding on all subordinate courts and tribunals situated in the country, in the same sense that the laws declared by the Supreme Court are binding on all courts. So that is also a kind of things of controlling jurisdictions. Okay. Now we shall come to the another jurisdiction, that is court of record. Court of record. Court of record. Article 215. Court of record we have already discussed, understood it while we were discussing Supreme Court, and there are two major aspects of courts of record. One is that the court has the power to punish for its own contempt, and whenever there is a contempt against it or there is a contempt related to its court, then it has the power to decide the contempt and punish accordingly. Another thing that you can also mention, that the judgments of the court are preserved for perennial purpose, for future references. So these are the meaning of the court of record. The judgment proceedings acts are recorded for perpetual memory and testimony. You can write that. The judgments, proceedings and acts of the High Court are recorded for, the best word is for perpetual memory and testimony. Perpetual memory and testimony. That is the first meaning of the court, the contempt of court. These records are admitted to be of evidentiary value and cannot be questioned. Okay, next. These records are to be of evidentiary value and cannot be questioned. Please take a note of this. Okay. So cannot be questioned when produced in a subordinate court. The records, the judgments of the High Court cannot be questioned because it has evidentiary value. So they can be taken as legal precedents or legal references, like the judgments of the Supreme Court. So in India, under the judiciary system, two courts are courts of record. One is Supreme Court under Article 129 and High Courts under Article 215. So these are the meanings of the court of record, that their judgments and records are of evidence. Another thing is that we can take a note of that under the meaning of the court of record, that the courts have the power to punish for its own contempt. The courts have the power to punish for contempt of court. It has the power, and either with simple imprisonment or a fine or both, it can do that. So that protects the dignity of the court, the respectability of the court on that way. Okay. So now we shall see the content number 2. Number 3. It has power to punish for contempt of court, either with fine or a simple imprisonment, not rigorous imprisonment, or both. And while discussing contempt of court, I have probably told you that contempt of court is not mentioned in the Constitution. It's not mentioned in the Constitution. It is not elaborated, defined in the Constitution. only the latter the Parliament enacted Contempt of Court Act 1971 upon the recommendation of H.N. Sanyal Committee, H.N. Sanyal Committee recommendation in 1963, and 71 Act was enacted, and the Act contains civil contempt and criminal contempt of the court. Okay, so that is the thing. So High Court has the power to punish for this own contempt. So the court of record has dual meaning, two major meanings. One is judgments or precedents are preserved for the perennial powers, and that is okay. So now this is the power of the contempt, or that is court of record. So it is also a kind of jurisdiction of the High Court, Now, power of judicial review. Power of judicial power of judicial review. So we have discussed a little bit about judicial review. Judicial review is a power of the judiciary to review any act or orders of the executive or the state legislature to establish their constitutionality or to ensure that they conform to the Constitution of India. They are not violative of the Constitution. This is a very unique power of the court to bring democracy in practice and to enable the people to realize the rule of law or rule of justice. Therefore, the power of judicial review is considered a basic structure of the Constitution in various cases also. So it was declared as the very central theme of the Constitution, central tenet of the Constitution. If you take away the judicial review, then it is not there. So if any act or any order or any bylaw upon being examined by the judiciary is found to be unconstitutional or against the spirit of the Constitution, then such act, such order, such bylaw shall be declared null and void by the court. That is called power of judicial review. So under Article 32, the Supreme Court, under Article 23, 13 also, and 226, 32, under Article 13 and 226, the High Court enjoys the power of judicial review. Under Article 13 and Article 226, under Article 13 and 226, confer the High Court is conferred with the power of judicial review. The High Court can review the acts of Parliament, state legislatures, executive orders, bylaws, etc. to establish the constitutionality. Their constitutionality. Please take a note of this. Okay, so these are the major points. Now, the constitutionality of a legislative act or executive order can be challenged under the following circumstances. Number one, if it infringes fundamental rights, number two, if it transgresses the other provisions, the provisions of Constitution, number three, if it is outside the competence of the authority which has enacted it. Okay. This power of judicial review of the High Court was curtailed by the Supreme Court under 42nd Amendment Act 1976, but later it was restored by 43rd Amendment Act 1977. So it is considered a basic structure. Please take a note of this. Okay. So this is all about the High Court system, and if you compare the Supreme Court and High Court in that light, Supreme Court is the highest court of appeal, highest court or highest judiciary in the country, and High Court is the highest judiciary in the state level. The original jurisdiction of the High Court belongs to the state matters only, but Supreme Court is a federal court and it decides the federal disputes, which are the exclusive authority of the High Court, Supreme Court. Okay, extent of power. The High Court has unlimited powers in case of large powers in case of appellate jurisdiction. It hears appeals. Okay, so there are a lot of differences between the Supreme Court. There's substantial difference between the Supreme Court and High Court in their power, in their extent of power, jurisdiction, in the appointment also, and other things that are also there. We shall discuss more about it towards the end of the chapter. Now we shall be coming back to, we shall be now going to subordinate courts in India. Subordinate courts. They are called subordinate because I think they are under the subordination of the High Court. They are directly under the supervision of the High Courts. Hence, they are called subordinate courts in India. So, if you look at the structure of the subordinate courts in India, you will find that there are different types of courts, like your civil court and your session court or criminal court, and there is also your revenue court. In civil cases, district civil judge, district civil judge court, then there sub-judge court, then there are municip courts. Municip courts are there. Then in criminal side, there are district session judge, chief judicial magistrate, judicial magistrate, or metropolitan magistrate in metro cities also. And in case of revenue, that is revenue court, RDC, regional division circle, RDC. Then you have the district collectors, then you have tahsildars, and then RI, revenue inspector. Okay. So that is the structure of the subordinate courts in the state and they are uniform across the country almost. Apart from them, there are other courts also, commercial courts, tribunals located in the country, but subordinate courts are mentioned in the constitution itself. Well, okay, now the constitutional provisions. Constitutional provisions of subordinate courts. So Article 233, Article 233 to 237 in part BI deals with the subordinate courts. Okay. So now the qualifications. Qualifications of district judges are citizen of India, number 2 should not have been judicial service. Pleader, seven years. Okay. Okay, and another things also to be added, number 4, here C should be recommended by please take a note of this. Okay, so these are the basic qualifications required for the qualification of for the appointment of district judges. Okay, 4 qualifications are there. Then appointment. District judges are appointed by the governor in consultation with the State High Court. In consultation with the High Court. Other members of the subordinate judiciary by governor and the High Courts. Okay. So these are the major factors. Please take a note of that. Okay. So these are appointed, other members are appointed not only by the governor, not in consultation of the High Court, but also in consultation with the State Public Service Commission, like OAS in this case. And another thing, control over subordinate courts. The High Courts controls the subordinate court. We have already discussed that it controls the it is consulted and its opinions are binding in case of posting, appointment, transfer and promotion of the district judges. It also regulates the various aspects of the subordinate courts. The control over subordinate courts lies in the hand of the High Courts. Okay, because salary and others are decided by the subordinate courts, by the parliament. So they are also to some extent independent also. They enjoy protections under the domain of the High Courts. Okay. Now the original the jurisdiction of the subordinate court. If you will find the subordinate court has also substantial jurisdiction in matters of original or appellate jurisdictions. They can also issue public interest litigations, so motto. So they have been also posed at the common man's court at the district level. So subordinate courts has both original and appellate jurisdiction in India. With regards to original jurisdiction, it hears all criminal and civil matters. The the district session judge, district session judge can award any punishment, any imprisonment to any person who is accused of or declared accused by it. But it cannot confer or declare death sentence on the person unless it is approved by the High Court. So only in the matter of death sentence or capital punishment, the matter is left to the High Court, otherwise they have the extensive original powers in that case. In case of Chief Judicial Magistrate, the authority can award a punishment period up to 7 years. That is also a kind of things you have to remember, and the judicial magistrate can award up to 3 years of imprisonment at a time. So the variance in the jurisdiction or variance in the powers also makes them subordinate, one below another. And in case of civil matters also, the powers are also being it's being distributed. The district civil court has quite significant power to impose fines and regulations of any amount. That is, some limit is fixed also. Then the sub-judge court has a limit also, and the municipal court has the lowest limit of fine in that case. So this is your original jurisdiction of the High Court. Original jurisdiction we have finished. We have finished it. Yeah, just a little bit idea about tribunals. Tribunals are quasi-judicial bodies or extrajudicial bodies, you can say, established to relax the traditional courts. Lot of measures have been taken to deconcentrate the courts or deconcentrate the judiciary and leave the Supreme Court and High Court to decide higher cases or cases of higher importance or constitutional matters. Hence, there have been many measures taken by the government to establish several judicial quasi-judicial bodies in this regard. Tribunal is one such initiative, and it was is also found mentioned in the Constitution in XIVA 14A, which was added by 42nd Amendment Act 1976. And so tribunals are 14 XIVA and Article 323 to 323B. There are great difference between tribunal and courts. Tribunals decide cases on natural justice, whereas courts decide on laws, traditional laws and regulations. I mean, the justice delivery power of the court is limited within the scope of the law, but tribunal can extend it to natural justice. Tribunals are set up under Act of Parliament or Act of State Legislature. Courts are constitutionally mentioned. Courts are constitutionally mentioned and their constitutional bodies. Courts decide all matters, whereas tribunal will deals with specific matters for which they are established. For example, tax tribunal, agricultural tribunal, rent tribunal, or any other tribunal there. In the constitution, there are two types of tribunals are meant to be provided. Under Article 323A, the administrative tribunals are provided. The administrative tribunals deal with the disputes or matters related to services under the government of India and under the government of the states. The administrative tribunals are established under an Act of Parliament. The Central Administrative Tribunal Act 1985 has been enacted to provide the establishment of a tribunal to deal with service matters of the centre and states, and the central government has already established it. In case of state administrative tribunals, few states continue to have a state administrative tribunal. Odisha used to have a administrative tribunal, but in 2015 the Odisha State Administrative Tribunal was dissolved. So the efficacy of the tribunals seems to be a very great or a big question mark. Had they been efficient, had they been effective, then there would have been number of tribunals, administrative tribunals set up in the country in various states. The problem lies in the system also. It was provided later when it was established in 1985 onwards. It was provided that appeal against the tribunals should lie to the Supreme Court. But afterward, the Supreme Court declined to interfere in this matter and said that any appeal to the against the judgment of the tribunal must lie to the high courts. So that is the thing about the procedure of the tribunals. So administrative tribunals are established under Article 323A, and they are of two types. One is Central Administrative Tribunal, another is State Administrative Tribunal. Central Administrative Tribunals are established under an Act of Parliament, and that there are also a chairman and another members are also there. It was there. Okay, so that is also a point to be noted. And tribunals are not bound by natural justice, bound by traditional laws. The State Administrative Tribunal is established under the same act by the state government also. And the tribunal, Central Administrative Tribunal, has a chairperson and other members. Sanction strength of the Commission of the Sanction Strength is 65 at present. You can take a note of that. The sanction strength of the CAT, Central Administrative Tribunal. In Article 323B, the other tribunals in other matters are established also. Tribunals in other matters are established also. Tribunals in other matters means taxation, foreign exchange, and industrial labor, land reform, sealing and property, foodstuff, rent, tenancy, election of the parliament. So for many purposes, parliament and the state legislature are authorized to provide for the establishment of tribunals. So what I mean to say you, that for administrative purpose, the tribunal should be set up by the parliament, and for other purpose, it may be set up by the parliament or the state legislatures. And both are governed under the acts, so they are statutory bodies to function under the acts. Tribunals are expected to do a pioneering service to the nation and to clear or deconcentrate the courts. But as I told you, the administrative courts has not been a very successful experiment of the government. In most of the states that was established earlier but now got abolished, because of all the appeal lies to the high courts, and the deconcentration of courts, or the the over number of cases, growing number of cases doesn't seem to be reduced, rather it was increased. So the objective was defeated, the objective was not fulfilled, hence the states could not see any benefit in having a large body that is called tribunals. So in case of other tribunals, I told you they can be established by Supreme High Court and they can be established by High Court and state legislature. So other matters means taxation. In case of taxation, there could be a tribunal. In case of foreign exchange and regulations, can be a tribunals. In case of industries and labors, can be a tribunal. Land reform, selling, rent, foodstuff, tenancy rights, election to parliament or state legislature. So all tribunals can be set up also, and they are also they help build the democracy. Okay, now the CAT has several benches in states and union territories that I can see. So there are 17 spaces. That was there 17 benches of CAT in different parts of the country. Okay. So these are the things we have discussed. Now we shall move to the questions based on the High Court and Supreme Court. There are very easy questions I have provided also. So you can do it well. So now we'll come to the questions. Okay. Now I can do it. Please look at the questions. Okay, so what will be the question answer to the question number 1? Common High Court for 2 or more states can be established by Parliament by law under Article 231, Parliament by law. Under a single integrated hierarchical judicial system, the High Court in the states are directly under the Supreme Court of India, D. Who decides the number of judges in High Court? The President decides the number of judges in High Court. Number 3. Please look at the question and work out on your own. I'll bring answer for you. Okay, number 4. Which of the following union territories have their own high courts? So we have so far 2 union territories as of you know. B, the Family Courts Act for Redressal of Family Disputes was first enacted in 1984. Family court is also a type of subordinate court that was established in 1984 under the Act. It is headed by a judge, qualified judge. It deals with disputes related to the family matters. That is also a kind of things. Okay. Which of the following articles deals with tribunals? The tribunals is both 323A and B, D. That is B. Look at the question first. So here in column A it is given the name of the states and column B gives the names of headquarters. So we have taken a list of that also. Madhya Pradesh, Jabalpur, Chhattisgarh, Bilaspur, Rajasthan, Jodhpur and Kerala, Ernakulam. I mean 2143. Is that clear? 2143. Match the following: 214 establishment of high courts, 215 high court is to a court of record, transfer of judges, and that is common high court. So you can express that 4321. A separate high court for Telangana came into existence on 1st January 2019. It was renamed or recasted as Telangana High Court. So kindly take a note of all this. Question number 7, 8, 9, and we have already discussed these factors. Consider the following states, correct the chronology of the high courts in India: Bombay, Odisha, Sikkim and Tripura. Do the answer first, do it, I shall tell you. Okay? Is your answer ready? So first is Bombay High Court, one of the oldest High Court in Odisha, in India, 1862, and it is 2014. It is 1970. Sorry, it's not 2015. 1948. 1948 and 1975, 2013. So it is 1, 2, 3, 4. 1, 2, 3, 4. Which of the following High Court's headquarters is not located in the state capital? Rajasthan. D. Jodhpur is the state capital, not state capital. Okay. Which of the following not correct regarding the appointment of the High Court judges? So what do you think? What will be the right answer? They are appointed by the President, all right. The President consults the Governor of the state in the appointment. Okay. The Chief Justice is consulted in their appointment. They must be a permanent resident in the state. So that is inappropriate option. They need not to be a permanent resident of the state. D. Which of the following is not a common High Court in India? So Allahabad High Court is not a common High Court in India. D. All others are common High Court. The district judges are appointed by President in consultation with the Chief Justice of High Courts. Governor in consultation with the High Court. So C. Please take a note of this. Who became the first Chief Justice of the Telangana High Court? Totally B. Radhakrishnan. A. The pension of the High Court judges are charged on the Consolidated Fund of India. A. The salary and allowances of Lokpal of India, there is a out of contest question also. But anyway, that is a question. Chief Justice of Chief Justice of India, Lokpal is the highest anti-corruption authority in India, established under Lokpal Act 2013. It has come into effect in 16 January 2014, and in 2019 the first Lokpal was appointed. He gets salary of the Chief Justice of India, and Chief Justice of India. Take a note of this. The Bombay High Court has benches at the following except Pune. Pune, there is no bench of Bombay High Court at Pune. It is Nagpur, Panaji, Aurangabad. That is also possible. Okay. Who became the first woman Chief Justice of a High Court in India? Justice Leila Seth. B. She was the Chief Justice of Himachal Pradesh High Court, and it was in 1991 to 1993, and she became the first woman Chief Justice of India. Who among the following is eligible for becoming chairperson of National Human Rights Commission? So the correct answer is B. You can take a note of this. The National Judicial Appointment Commission was established by 99th Constitutional Amendment Act, which came into existence in 2015. Later I told you it was abolished or it was declared ultra virus in 4th Judge case 2015. In 4th Judge case 2015 it was declared as unconstitutional ultra virus also. So 22 we shall see the provisions of appointment of district judges is provided under Article 233. District judges appointments are provided in 233B. Okay. What is the minimum age requirement for becoming a district judge in India? What is the minimum age requirement for becoming the district judge in India? There is no age bar. D. Unlike High Court judges and Supreme Court judges, there is no age bar of Indian Supreme Court. The first High Court was set up in Calcutta in the year 1862, and I told you under one act, the three were Madras, Bombay and Calcutta were set up. Odisha High Court was established on 26 July 1948, option D. So here option is B, here option is D, D and B. Now correct chronological order of the High Courts: Gujarat High Court, Manipur High Court, Himachal Pradesh High Court, Odisha High Court. Gujarat High Court was in 1960. Manipur 2013, and it is 1971. And it is 1948. So 4132. 4132. Okay. That is 26. So here all these things are there. So we have to now just finish the things. So this is your part of the judiciary we have finished. We will start with the state part now. We have finished the judiciary at a time, and there are certain issues related to judiciary. We shall discuss it somewhere also. But we are completing or going through constitutional parts. Constitutional parts in this case. So now we shall be proceeding with the state part. In the state part, we shall be discussing state executive, state legislature, and we have already discussed state judiciary. So state executive will be the next chapter. We shall be starting this one and continue up to the next class. State executive. In this part, we shall be discussing the constitutional provisions, that is part VI in Article 152, 152 to 230, 167, 167. And in this part we shall shall cover the provisions related to the governors of the states, the chief ministers of the states, and we shall also see the Council of Ministers, and we shall see also the Advocate General. But before that, let's just remind me about the role and function of the executive. We have discussed when we are discussing union executive, what are the roles played by the state executive? The executive, state executive is a plural body. It is not a singular body. It is vested in a group of members or group of ministers. So first of all, state executive is plural body or pluralistic in nature, and it executes. So it is pluralistic, plural body, pluralistic in nature, not vested in the single person. The executive power of the state, executive power of the state is vested in the Council of Ministers, headed by the CM. It means that if the state executive is not, or executive power of the state is not vested in the single person, it is vested in the number of persons. And another thing you have to note also, the executive implements the law, executes the law, enforces the law. So it executes the law. It is the face of the government. It declares policies, it reforms, changes, suggests measures for reforms, it makes the law active. So executive in a parliamentary system has dual role to play. Likewise, in a state system, executive has also the same role. It functions, it has dual functions. Matlab, we shall see that dual functions of the executive. There are certain dual functions of the executive. So, unlike a presidential form, the executive in a parliamentary form or parliamentary government has more responsibility, powers than the president. So if you talk about the dual role of the state executive, it is similar. Just I will remind you all about this. There are two major roles of the executive is that one is the legislative aspect of the legislative aspect of the executive, and executive function of the executive. which is its inherent part. So as an executive, it is the head of the government. It is the head of the departments or business of the government is run. But as a legislative, it is also the leader of the legislature. It is also the leader of the legislature. So it not only ensures proper execution of law, but also ensures the proper enactment of law. And these two are called the leader of the executive and head of the executive. And this is called the dual role of the executive. Okay, and as the executive of the head of the executive, it what does it do? Now it implements the law, implements laws or policies, programs, etc. It also suggests or proposes, it does not do it, it proposes reforms. It proposes reforms in the law. And it also coordinates, brings coordination among different departments, brings coordination of different departments related to, brings coordination. Coordination between or among the stakeholders of the government. Any stakeholders, between the coordinations of stakeholders of the government, either bureaucrats or institutions, anybody who is associated with the government. Here as a leader of the legislature also, he ensures smooth functioning of the government. Smooth functioning of the legislature. Okay? And also decides the type of legislation. Because why this happens? Because the executives or the ministers or the prime ministers chief ministers are the members of the state legislature or the Vidhan Sabha. Hence, they are also duty. So it is obvious for all of you to understand that why the role of executive in a parliamentary setup is much more critical than the role of executive in a presidential system. That is, there the decision making is singular in nature, singular decision making body, but here the decision making is plural. So this is the answer to the question कि responsibility of the executive is more than that in the presidential form. Okay. Now we shall come to the brief introduction about the legislative or the state executive, the governor. In fact, the Constitution mentions about the governor as it mentions about the president also. Both are the head of the state at the central or state level. If we come back to the origin of this office of the governor, can be traced back to the days of the British colonial days or colonial period. It was initiated during the East India Company days. The governors were leading or were the heads of the presidencies during the presidential government, during the East India Company rule. And since then, the gubernatorial office has undergone substantial changes. And the makers of the Constitution intended to provide the same parliamentary system of government in the state level, and hence the governor is provided or is there at the state level. Okay, the office of the governor in Article 153, Article 153 says that, Article 153 says that there shall be a governor in each state. But this provision was changed by Parliament by 7th Amendment Act. So by 7th Constitutional Amendment Act 1956, there was a change. And what was the change in the provision that brought by the 7th Amendment? It was provided that the same person can be appointed as the governor of 2 or more states simultaneously. So that was the change that amended Article 153 and provided that a person can be appointed as the governor of the same state, 2 states at a time. And when a person is so appointed as the governor of 2 or more states, what happens to his salaries and allowances? It remains the same. The salaries and remains of a person who is appointed as the governor of 2 or more states remains the same. But the share of the state is to be decided or determined by the president. Okay? So we are just introducing the governor. It is next class we shall be dealing with him in detail. So we are now at state part. We have completed the union part, union legislature, union judiciary in total. Now we will move through the state part, and in state part we shall be dealing with all these things, all these offices, office of the governor, chief minister and others. We shall also discuss the Vidhan Sabha, Vidhan Parishad and other in the state legislature part. Okay, and then we shall come down to the local self-government. Okay. So let me bid you goodbye today. It's the class now here, and in next class we shall be starting with the governor. So next class we shall be starting with governor. Governors of the states. We shall introduce it. We shall introduce the governor again, and how he is compared with the President of India and how he is there. All right. So thank you very much to all of you.